Good morning, everybody. My name is Johannes Leitenberger. I'm the Director General of the European Commission's Competition Director General, and I have the privilege and the pleasure to guide us through this first panel of the 17th OECD Global Forum on Competition, on the theme of the event, how can competition contribute to fairer societies? That is an urgent, an exciting and a challenging theme, and I think the illustration of the urgency and the excitement is the fact that for once Fred Genie has left his rightful place as the moderator to me, because he really wants to intervene on the substance. And I think we are really fortunate to have this excellent panel with a diversity of substantive and of geographical views and perspectives. So may I introduce Professor Pinar Akman, the Director of the Center for Business Law and Practice of the School of Law at the University of Leeds, Mr. Arsenion Balizacan, the Chair of the Philippine Competition Commission, Professor Jonathan Baker, Research Professor of Law at the American University Washington College of Law, and then, as I said, not needing any introduction in this circle, Professor Frédéric Genie, the Chair of the OECD Competition Committee and Professor at ISEC, among very many other functions, qualities, and experiences. Before we move on to the presentations, let me make a few very quick remarks to set the scene for our debate. In the wake of the financial and economic crisis, or should I say crises, that we have seen over past decades, and in particular over the last 10 years ago, in Europe, in the United States, everywhere in the world, uneasiness and discontent have grown. This has had an impact on every public institution, but it has maybe had a special impact on competition authorities. After all, if there is a perception by consumers, by businesses, by citizens that, quote, the game is rigged, unquote, or that, quote, the system works for the few, not the many, unquote. This is a particular challenge for competition authorities that are tasked with ensuring consumer welfare through undistorted competition. It is a particular challenge to the conviction that a discovery process empowered by undistorted competition is the best tool that we have to deliver consumer welfare. And then it is an even greater challenge, I think, for the jurisdictions where the very fairness ambition is embedded in the law for competition, as is, for instance, the case in my jurisdiction, the European Union, where fair competition is identified by the legal texts as a bedrock of what we should strive for and what we need to ensure. You may see this as an attempt avant la lettre to ensure acceptance and legitimacy by procedure, to refer to the term coined by the sociologist Niklas Luhmann, legitimacy through due process in the way how we apply the rules, and legitimacy through a competitive process that is delivered on the merits. And I think the merit notion makes the link with fairness very clear, because very intuitively, all of us, we see an outcome fair that is acquired on the merits, and an outcome as unfair that somehow is not acquired on the merits. But what does it then mean more in detail? Is it just a communication issue? Is the perception of unease and discontent out there because we have not been able, as competition authorities or the competition community, to explain correctly what we do and why we do it? Or does it go further? Is it a question of applying an essentially correct framework of legal rules and economic analysis better? Have we not applied it forcefully enough? Or, to be completely intellectually rigorous, have we applied it too forcefully? Or do we still need to get a step further and ask questions about the framework itself? Do we have the right legal rules? Have we missed something in economic analysis? And finally, that will then also lead us to the question, what can competition authorities do, and where do we, as competition authorities, need to give space, to give way to other regulatory disciplines and to other actors maybe better placed than us to address these issues. So it's a vast field that we will try to touch upon this morning, but I think it will, in different dimensions and different ways, come back to the same question: can we make sure that the invisible hand is not deflected through collusion or strong-armed to abuse, and what does it take in our present economic and societal environment to ensure this? And there may not be a one-size-fits-all answer, and that is why it is so precious that on this panel we have a diversity of geographical, but also of professional specializations, and why we have this global forum where I will hope that all of this, on the basis of the presentations that we will hear in a moment, will spark a lively, controversial, and ultimately enriching and stimulating debate. After the presentations from the podium, already 2 interventions from the floor have been announced, which I will take immediately after the presentations from the podium, namely by the United Kingdom and by TUAC, the Trade Union Advisory, and then the floor will be open to all of you with your contributions and your views. So far from my side. Now over to Professor Ackman, who will set out a legal view on the issue of fairness and competition. You have the floor.
Thank you, Director General, for the introduction, and I would like to thank also the OECD's Competition Division for this invitation. I'm honored to be here. So the subject matter of this panel, and I think the Global Forum this year, is how competition can contribute to fairer societies. And the OECD has set this up as a question to us. I think it's a bit of a trick question because the OECD's Competition Division have come as close to giving the best answer to that question as one can do, in my opinion, in one of its many excellent research papers when Sean Ennis and his colleagues said that policies that enhance competition, essentially by their nature, can help to reduce inequality. So if we take inequality as one understanding of fairness, then by enforcing competition, really competition authorities would be, as a byproduct, also reducing inequality in a society. But they also said that this is not to say that competition law and policy should specifically target inequality in day-to-day competition actions. So what I would like to do in my talk is to look at the role of fairness or the role of unfairness in competition law enforcement specifically, and how competition authorities should or should not take that into account when doing their essentially daily business of enforcing competition law. So just in case I lose you in the next 20 minutes, this is really what I would like to say in summary. So I think fairness has a limited role to play in competition law enforcement, and I can think of several ways in which fairness might be taken into account for good reason by competition authorities. But I can also think of many other reasons, or in many other ways in which fairness should probably not be taken into account in competition law enforcement. I'll have enough time to pick up on some of these, but not all of them. So just to tell you sort of the underlying principles here, I think fairness should almost certainly be taken into account when it comes to procedural fairness and how the authorities actually enforce the law. And if we look at prohibitions of bid rigging and prevention of state aid, I think there's an element of fairness there as well, which makes a lot of sense and is quite clear, and I'll come to that in a minute. And we also have some rules in numerous jurisdictions, not least the European Union and those jurisdictions who have modeled their competition laws on the law of the EU. There are rules which explicitly refer to a notion of unfairness, such as the prohibition of unfair pricing in the EU and many other jurisdictions. But I'll use this as a case study later on in my talk to show that even when there's an explicit reference to fairness in the rule, it might be so challenging to actually enforce it that the outcome might be just formidable in terms of doing this as part of an authority's practice. I also think there are some ways in which fairness should not be taken into account in the competition law assessment. For example, I don't think that it would be right to substitute any notion of unfairness or fairness with an assessment of the anti-competitive effects of a product on the market in question. So I don't think fairness could replace what authorities currently do with economic principles on the basis of economic evidence. And I don't think it's necessarily appropriate for authorities to pursue cases on the basis that the practice appears unfair, no matter how unfair that looks. And I think it's also, this is probably the most challenging aspect of using fairness or unfairness in competition law assessments. I don't think it should be also used to protect competitors of a company from competition. And here we see a tension between unfair competition laws and competition laws, which again I'll come to in a minute. So why do I think that fairness has such a limited role to play? I think those of you who are lawyers in the audience will be familiar with this distinction between procedural fairness and substantive fairness, not just in competition law, but in all areas of the law. And we see that the law, as well as judges who decide on cases that are brought to them on the basis of a certain aspect of unfairness, are a lot more comfortable with scrutinizing procedural fairness rather than substantive fairness. And by this I mean the substantive fairness of an outcome. So if we look at many other areas of law, contract law, consumer law, even unfair commercial practices law, we see that none of these actually scrutinizes the fairness of the outcome, so the fairness of the bargain, which in a transactional relationship would be the price. And even in cases where the law actually does scrutinize some aspect of the bargain that the two parties have reached, because the outcome that they have reached in their transaction looks grossly unfair, even in those cases, at least the jurisdictions I'm familiar with, would look at the procedure to see whether something has gone so badly wrong in this procedure, in this process of bargaining between the two parties, that they have ended up with such a bad bargain for one party. So some of these were mentioned, I think, yesterday as well when the discussion was on excessive pricing in pharmaceuticals. So some parts of the law, like contract law and so on, scrutinize things like inequality of bargaining power or economic duress, where there's something so wrong about the procedure between the two parties. Essentially, one is signing a contract with a gun to their head. And that's what explains the unfairness of the outcome. So even when the law is interested in the outcome, it's usually through the indirect means of scrutinizing the process through which that outcome was reached. And I think it's the same in competition law. There are many aspects of procedural fairness which are explicitly and clearly on the rule books, and for good reason. The right to be heard, access to file, the opportunity to have an oral hearing at proceedings before competition authorities, and all of these make a lot of sense because they ensure that whatever outcome is reached, it's reached through fair means of procedure. And I said that we can even think of rules against bid rigging and state aid and so on these same grounds, because what happens when a government gives a state aid to one party and not the other is that the process of competition between those companies is disrupted through essentially a subsidy to one party, which the other party doesn't make benefit of. So again, there is an element of procedural fairness, even in the prohibition of bid rigging and state aid. But what we see is that as soon as the assessment of fairness starts to move from this procedural aspect to a more substantive fairness assessment, there are formidable difficulties. And the first one of these is that we don't know what fairness means. And it's not that we haven't got an idea. I think research shows that even monkeys have an inherent feeling of unfairness. They know when they have been unfairly treated. But what does it mean in practice? Can we agree on a single definition of fairness which we could use for a legal assessment of a business's practices? I just picked 4. I could probably pick many more. So when we talk about fairness, do we mean that everybody should be treated in the same way? Or do we mean that only like for like should be treated in the same way? Or do we mean distributive justice? So we shouldn't treat everyone in the same way because some parts of the society are more deserving than others on some occasions. Or do we mean fairness means an eye for an eye and a tooth for a tooth? So this is, for example, what some behavioral models suggest, that when parties are reacting to unfairness, what they're doing is they're returning what they perceive to have received from the other side. And I'll come to that later as well. Let's assume we think we can find a single definition of fairness, but who's supposed to decide on this? Who makes the judgment that a certain practice is fair or unfair? And perhaps more importantly, when do they make that decision? Do they or can they make that decision of unfairness ex ante? So before a given conduct takes place, they can tell us if A and B happen and then the outcome is unfair. Or is this mostly an assessment that's done ex post? So something happens, we end up with a situation, and then when we look at the situation, we think, okay, this looks really unfair. But could we have defined what we find unfair ex post, ex ante? Because this is quite important in the area, any area of business law, because there has to be some business certainty and legal certainty. And finally, what are the criteria, objective criteria, on which that judgment of fairness will be made by whomever has the authority to make that judgment? So not only is there a long list of definitions of fairness, I think many of these are potentially also contradictory with one another, and it's again something I'll turn to in a moment. But before that, I'd like to point out another challenge for competition law when it comes to an assessment of fairness. And this is quite important, in particular for competition authorities, because any authority who would like to take this idea of fairness and unfairness seriously will have to decide on this particular question. Who are we supposed to be fair to? So are we talking about fairness to competitors? Is it about protecting the competitors from one another when we think one of them is acting unfairly? Well, if that's the case, then we come pretty close to the prohibition of unfair competition. And those of you who have separate laws in your jurisdictions, unfair competition laws and competition laws, will know that they're not the same area of law, and they actually have very different purposes. Whereas unfair competition law explicitly really aims to protect market participants from one another, competition law does not aim to do that. Competition law aims to protect the competitive process on the market in the interest of all market participants. And the Court of Justice of the European Union has expressed this quite explicitly in one case where it said that sometimes rules of unfair competition may actually be anti-competitive in themselves because it's about protecting the competitors for the sake of protecting the competitors, not about protecting competition on the market. So in that case, the Court of Justice gave a ruling in relation to an unfair competition law prohibition, which prevented eye-catching individual price comparisons. So this was unfair according to the unfair competition law of the member state, but the court said, but there's nothing, this in itself is anti-competitive because it's preventing a legitimate type of price comparison or price competition from taking place on the market. So fairness to competitors is one alternative, but I can think of many other alternatives. We might mean fairness to customers, or we might mean fairness to consumers. And not even those two would give us the same results in a given case, because the interests of the customers of, let's say, a dominant undertaking are not necessarily aligned with the interests of the consumers, the final users of the product that that dominant undertaking is selling. So think of any two-part tariff situation or vertical restraint. A practice that harms the customers of a dominant undertaking may even benefit the final consumers of that product and vice versa. So who is it fairness to? We could mean fairness to competitors and customers and to consumers, but in reality, that might just be impossible to achieve concurrently, because again, those interests will not be aligned. And I'd like to take two examples from a particular competition law prohibition, which is the prohibition of Article 102 of the Treaty on the Functioning of the European Union, to demonstrate how, when authorities try to enforce rules with aspects of fairness, they run into formidable challenges. And it's not the authorities' fault. I think these are inherent challenges. And the examples I'll take are the prohibition of unfair pricing and then the prohibition of discrimination. So as some of you in the audience will know, according to Article 102, it's an abuse of a dominant position where a dominant undertaking directly or indirectly imposes an unfair purchase or selling price. And unfortunately, I missed most of the discussions yesterday, but I know that there were some heated debates about what unfair pricing means yesterday evening, both at the competition committee meeting and then also at the Women at Competition meeting. But strikingly, I think the meetings were actually phrased around the prohibition of excessive pricing rather than unfair pricing. And I think that's telling. It's telling because actually nobody would like to really think about the unfairness element of that prohibition there. And it all seems to be about excessiveness, which is not what the prohibition in the EU prohibits. So the United Brands case was, again, mentioned a few times in those debates last night. In United Brands, which is the seminal ruling on unfair pricing in Europe, the Court of Justice said a price is abusive if it has no reasonable relation to the economic value of the product. And then the court said there are two stages to deciding whether there is no reasonable relation to the economic value of the product. In the first step, the competition authority should decide whether the price is excessive. And when it's decided that it is excessive, it should then consider, and it's not an alternative, it has to then consider whether the price is unfair in itself or it's unfair when compared to competing products. So it's not a prohibition of excessive pricing, it's a prohibition of unfair pricing, and there are clearly two different stages. And this is partly why the Competition Appeal Tribunal recently sent the Pfizer-Flynn case back to the CMA, because of the second stage, because of the specific way in which one might think that an authority might have to prove that a price is unfair in itself or unfair when compared to competing products. But the EU Commission has rightly identified some years ago now the case law of the Court of Justice of the European Union and the case law or the decisional practice of the Commission do not really provide much guidance on how to determine whether the price is unfair in itself. And I think the same goes for deciding whether the price is unfair in comparison to other products. And as you know, there has been little case law on unfair pricing, and most commentary on the topic actually proceeds on the basis that what's prohibited is excessive pricing rather than unfair pricing, which is not the case. And I mean, there are numerous problems with this prohibition because let's think about it. How can the price be unfair if somebody has already purchased that product at that price? So if the price wasn't about the willingness to pay of if the price was about the willingness to pay of the customer shouldn't have bought the product. And really, if we want to have a competition law prohibition that looks at the level of prices, we should be more worried about the ones who couldn't purchase the product because the price was so high. So we should be focusing on the deadweight loss rather than the ones who have been able to purchase the product, because it's sort of self-defeating to say, I bought this, it was unfair, but I bought this anyway. So in my other research, I show that actually even in that instance, one of the only ways to make sense of that unfairness of the price is to look at the procedure, the bargain that took place between the two parties, and whether that's what makes the price unfair. So there are inherent problems with operationalizing the prohibition of unfair pricing. Now, there is a bit of light, so it's not necessarily all bad news, because we could, for example, look at behavioral economics to find out what unfairness might mean. If we're going to take the unfairness notion seriously, then I don't think traditional law and economics approaches will give us the answer to when an outcome is unfair. But there's a lot of work in behavioral economics which looks at different notions of fairness and unfairness. Again, in my earlier research, a colleague and I took one of these models, so the principle of dual entitlement from Kahneman and his colleagues' seminal work, to see whether this could be used to operationalize unfair pricing in competition law. I think it's probably one of the rare examples of actually trying to take a behavioral economics insight to implement a competition law prohibition. So the principle of dual entitlement, I won't go into details, but it's essentially about finding a reference transaction and then seeing whether the parties to the transaction that the authority is looking at would judge the outcome reached as an unfair outcome in comparison to that reference transaction. I won't go into details, and the reference to the paper can be found at the end of my slides. But even if we took such an example or such a model from behavioral economics and used it to implement the prohibition in competition law, well, we see that there are other insights from other behavioral economics models which actually suggest that the fair price might require discrimination, because according to those other models, which are equally valid, the fair price is actually one that's based on the willingness to pay of the individual in question, and therefore when everybody has different willingness to pay, the fair price for every individual will be different. So in order to price fairly, the company would have to price discriminate. But for a law like the European competition law or those that have been modeled on the EU competition rules, we see that this will create a serious catch-22 situation in the context of abuse of dominance, because the rules of the jurisdiction prohibit not only unfair pricing, but also price discrimination. So if the fair price is a discriminatory price, how can a dominant undertaking comply with both prohibitions, the prohibition of unfair pricing and the prohibition of discrimination? This is just a practical problem. But I think there's also a more conceptual issue with the behavioral models, because pretty much all of them involve relativity and subjectivity. So the notion of fairness is usually relative in a particular context between those two transactional parties, and it's also from the perspective of the parties to the transaction themselves, rather than an objective notion of fairness. And I think legal and business certainty would be undermined if we were to have a fairness concept that was based on subjectivity. Now, the final example I'd like to give in that context is actually a prohibition of discrimination, to show the dynamics between the ideas of fairness and unfairness, and also these different prohibitions which obviously have an element of fairness. As the OECD also noted a few years ago, price discrimination or any type of discrimination would most likely create an assumption of unfairness. When you talk to the people out on the streets, you say, if the company charges you this price for this flight and the person sitting next to you paid half as much as you, do you think that's unfair? Most people would probably say, yes, that's unfair. But if you dig a little deeper, we would see that actually there might be nothing unfair at all with that sort of discrimination, not only because it depends on what you mean by fairness, but also because discrimination may actually make that market more competitive, because it might have made more seats available on that particular flight. Now, I was careful enough to choose an example from the regulator in the UK rather than any competition authority, given the audience. And I'm hoping Ofgem is not watching. So a couple of years ago, Ofgem, the UK energy regulator, with all good intentions, imposed a non-discrimination license requirement on energy retailers in the UK and stipulated that energy companies cannot charge different markups in different regions. So it was a non-discrimination license requirement which stipulated that they have to charge the same markup wherever they're selling energy in the UK. And they did this explicitly on fairness grounds. And this was because they have a duty to look after the vulnerable consumers of energy, and they wanted to impose this non-discrimination rule to alleviate some of the disadvantages suffered by those vulnerable consumers. So what happened in the UK when the energy markets opened to competition was that entrants who were incumbents in their separate regions, who were monopolies in their separate regions before competition was introduced, entered each other's markets to steal consumers from the incumbents. So the incumbent in market A entered into market B to steal consumers from the incumbent in market B. And what they were doing was essentially they were trying to lower the price to steal consumers in their new markets from the incumbents. And Ofgem found that those who switched to the entrant in any given region was getting a much better deal than those who stayed with their incumbent. And it turned out that the ones who didn't switch to the entrant were mostly the vulnerable consumers because they didn't have access to, they didn't have the abilities to switch. So they were the poorer people in the society, and they were the ones who had less access to means of switching and so on, pensioners. And so it turned out that because those vulnerable consumers are not switching, the entrants are stealing consumers who would be able to get a better deal from the market anyway. So this was the rationale which made Ofgem adopt this non-discrimination rule. Now, what seems to have happened is that this introduction of the non-discrimination rule increased offline tariffs, but also massively increased the discounts that energy retailers gave for their online tariffs. So the non-discrimination rule essentially pushed the energy retailers to segment the market in another way. Now, they couldn't discriminate between regions, but they could discriminate between online and offline tariffs. And guess what happened? Well, what happened was that those very consumers Ofgem was trying to protect, the vulnerable consumers, were also the consumers who had less access to broadband. So they were the ones, again, who weren't able to benefit from the price reductions because the retailers were now giving the best prices for online direct debit payers. And most of those were not the vulnerable consumers that Ofgem's rule was supposed to protect in the first place. So it seems that actually the rule itself probably caused further detrimental distributional effects by the market segmentation along the lines of offline and online. And what also seems to have happened is that because that non-discrimination rule weakened competition for the most lucrative part of the market, who were the direct debit payers, because entrants' ability to steal consumers were diminished, most likely the prices for everyone went up because the margins of the retailers seem to have gone up, and there doesn't seem to be any other explanation than the fact that the discrimination rule actually made the prices go up for everyone. So I think there is quite an important challenge and tension between welfare objectives and fairness objectives, but sometimes, even with all the good intentions in the world, even pursuing a policy on the basis of fairness might actually lead to other unfair outcomes, even regarding the same group of people. So it's really very complicated. So to conclude, I think I'd like to again emphasize this distinction between fairness and welfare. And it has been convincingly argued many years ago by Professors Kaplow and Chauvel that legal rules are better selected on the basis of their effects on the well-being of individuals rather than notions of fairness. And just a sort of small note here, that concept of well-being of individual can well accommodate a feeling for unfairness if this is what makes the individuals in question better off. But it's not about ensuring or pursuing a notion of fairness. That would still be pursuing a policy on the basis of enhancing the well-being or welfare of individuals. And I think in the context of competition policy and enforcement, legal certainty has to be quite upfront when authorities are thinking about adopting rules or decisions based on fairness notions, because legal certainty is not only a fundamental principle in modern laws, it's also a human right in many laws, in many jurisdictions, and there has to be sufficient business certainty when the enforcement is directed towards business practices, so that before the event happens, before a practice is undertaken, before a contract is signed, the parties involved can know with sufficient certainty what the outcome or what the assessment scrutiny of their transaction or conduct might be if a competition authority were to look at that. And I think fairness poses a serious challenge for that business and legal certainty aspect of competition enforcement. And as I've tried to demonstrate in the examples of unfair pricing and price discrimination, even when it's pursuing explicitly a policy or an action based on fairness, the outcome might actually lead to unintended or might pose unintended consequences, because the dynamics of the market will not necessarily be predictable as well as the authority or the regulator might like to predict them in advance. Something really to bear in mind is that competition law is not unfair competition law, and even sometimes sophisticated authorities can fall into that challenge of not reacting because something grossly unfair has happened to a competitor, as opposed to reacting when the market conditions are distorted. And I apologize to Dr. Leitenberger for putting his statement from his speech. When I prepared the talk, I didn't know that he was going to be sitting on the podium. So I agree with Mr. Leitenberger on that. While fairness is obviously a guiding principle, it's not a tool for competition of authorities to pick off the shelf and go and apply it in cases that they decide to pursue. And as Commissioner Vestager said, most of the time, competition authorities get consumers a fairer deal simply by keeping markets competitive. And I think that's keeping markets competitive by applying competition rules with the traditional legal and economic tools that the authorities have. Thank you.
Many thanks, Professor Ackman, for this very rich introduction to this morning's subject. I hasten to clarify that I have no doctoral title. Okay. That is also part of the fairness to reserve academic honors to those who've actually worked on them. And with this, I would like to pass on immediately to Mr. Balisakan, who has a rich presentation for us that considers both legal and economic interpretations of fairness illustrated through the Asian experience. But I think that many of his points are actually relevant across jurisdictions. So you have the floor, please.
Thank you. Okay, let me start by saying that the idea of fairness is vague and debatable, and so I'm not going to go into that. I take a more operationally manageable track. And that is to simply, in this presentation, take fairer societies to simply mean a more equitable distribution of income or opportunities generally. So the simpler question is competition policy appropriate to address rising economic inequality in developing Asia as elsewhere in the world? The answer is quite straightforward. Countries are very diverse, economically and institutionally, and we will show that competition policy should not be taken in a vacuum. That diversity means that the competition policy and its effectiveness are not framed in a vacuum, and they are situated in particular space, time, and country's economic conditions and circumstances. And we will use the Philippines to illustrate these dynamics between fairness and inequality on the other, and competition policy and policies in general on the other hand. So let me proceed with presenting to you some data, some experiences of developing Asia. What you would note is, what we would note here is that Asia is, of course, the fastest growing region in the world, as you most of you would know. And in developing Asia, we find some of the many big countries contributing to that growth. And associated with that growth is rising inequality. As you can see there, the Gini increased from 38 in the 1990s to 45 in 2010. Contrasting that with the period in the 1960s and 1970s when growth did take place without necessarily or without substantial increases in inequality. And as you can see, even with that growth or rising inequality, poverty declined substantially. There's no comparable period in modern times where such decline in poverty has taken place. And contributing to that rapid decline in poverty is the structural transformation that's taken place in many of the developing countries, where employment opportunities were created for the vast number of unskilled and skilled workers, particularly in manufacturing. And this was facilitated by globalization, technological change, and in many cases, adoption of policies that are friendly to investment and growth. Okay, Asia as a whole has grown, and as I said, you see substantial poverty reduction, but there are huge differences across developing Asia. We find low inequality countries at the start of rapid growth, and in those cases, we find a very strong response of poverty reduction to such growth. These are the cases, for example, for China, Vietnam, Indonesia. But there are also countries where inequality has been high to begin with, and the response of poverty to growth, and that growth appeared was expectedly not as strong as in the first case. And I would like to use here the Philippines as one of those cases. And that's where the slides show you there the different countries, and you find that the three major countries, the big countries in that region, China, India, Indonesia, did experience rapid growth and did experience sharply rising inequality in those countries. We have also cases where inequality appeared to remain high. And interestingly, Vietnam is a very good case where there has been substantial poverty reduction, and yet despite the rapid growth, inequality has not increased that much. So it's one interesting case. Now, the reason we are interested in this developing Asia with rapidly rising inequality is that poverty is still a very quite extensive in the region, especially in many developing low-income countries, and the rising inequality poses a serious threat to further poverty reduction. But more importantly, this rising inequality may undermine the sustainability of the growth itself, to the extent that the inequality could reduce the potential for growth in the future. And there are three channels noted in the literature that could lead to such outcome. First is that the political polarization and breakdown of social cohesion that rising inequality would bring. such breakdown could inhibit or could stifle the investment climate and could therefore lead into future rapid growth, decline the future rapid growth. The other one is attributable to this imperfect credit market argument. That is that the rising inequality would reduce the opportunity for the poor to invest in public human capital, therefore leading to a waste of human resources, and such waste would lead to lower productivity and income growth. And the third channel, which I would want to focus on here in the rest of my presentation, is what's referred to as the economic power begets political power. That is the economic concentration and market power could increase political inequality and political power, reshaping the rules of the game that perpetuate economic inequality. In other words, economic power brings about concentration of market power that will then bring about changing in the rules of the game that favors the economic elite, and that would further perpetuate economic concentration. And that's an issue that's becoming more pronounced in some of the East Asian countries, particularly from Korea, for example. Let me turn to the Philippine case to illustrate some of these dynamics. That the Philippines is quite an interesting case because during the past 40 years, the country has an enviable record in poverty reduction vis-a-vis developing Asia. And this has been the combined impact or combined outcome of low per capita GDP growth in the country compared to most of its neighbors, and importantly, the weak response of poverty to growth, what I refer to as the low growth elasticity of poverty reduction. And the second one has been, or could be attributed to the persistently high level of inequality in the distribution of income and wealth or opportunities in general. In the literature, at least in the Philippines and some other countries that I've seen, there is that link between, causal link between excessive income inequality and lower future income growth. It's still, of course, debatable, but at least for the literature that we have seen, there is that increasing evidence. Now, since 2000, since at least late 1990s, the Philippine economy has been exhibiting quite remarkable performances, has grown quite remarkably well in this decade. It has become one of the fastest growing emerging economies in Asia and in the world, and it's quite interesting because of the attraction that it's getting. But at the same time, if you look at the social indicators, we find that growth remains to be weakly inclusive. The real wages hardly changed. The absolute deprivation remained high. So the question then is, given the channels that I mentioned earlier, can that growth can the growth be sustained? Now, I focus a bit on that weak response of poverty to growth, and we did find that even after controlling for measurement differences, you find that the country to be behaving quite differently from the rest of the country, the rest of the countries in the region, and that weak response of poverty to growth is appears to be quite robust. Now, the country has realized the problem with inequality, and in fact, the 1987 Constitution did mention about the problems with economic elites, and the problems with income distribution And since the reform efforts have started in the 1980s, the country has included competition policy as one of its driving, the key elements for getting the economy growing and sustaining the growth. But it took almost 25 years to get that law passed. In the meantime, other components of the reform agenda did take place, and that could have contributed to the growth that we have seen in the last decade. But then again, the persistent question is, will that growth be sustainable without the other leg, which is the competition policy? And so in the last 3 years, we have seen quite tremendous political commitment to finally pass a competition law, despite the pressure exerted by the elite. We get that law finally passed, and that is seen to as a key policy reinforcement of past reform efforts toward establishing a more effective competition environment. And I would like to note that the competition policy, as framed in the context of the reform efforts, is recognized as a key to sustaining rapid growth and achieving a more equitable distribution of incomes and opportunities. And it's part and parcel of the overall policy reform agenda. As I said, what has triggered that political commitment to pass a law in 2015, a comprehensive competition law in 2015, is the desire to get the economic growth, the observation that despite the recent economic growth, though rapid, it has not been inclusive, and this time the goal is to keep that growth rapid and sustainable. So the law that was passed and has quite broad goals, protecting consumer welfare and advancing economic development by preventing economic concentration and market power that unduly stifles competition. As we will see, despite the broadness of the goals and other considerations that come to play, like, for example, protecting consumer welfare, advancing economic development, public interest considerations, in practice, the Competition Authority employs filters to prioritize enforcement, recognizing that there are other policies of government to achieve inclusive growth, inclusive development, and recognizing that competition policy is complementary to other policy tools. And so when the Competition Commission exercises its power, with respect to cases, it looks at certain filters. For example, here we use in particular the impact on consumer welfare, the likelihood of success, resource constraints, and whether the Competition Authority has jurisdiction on cases. Now, I said that I should note that the competition policy has been mainstreamed in the development agenda, and unlike in many other countries, at least in our region, it is part and parcel of the Philippine Development Plan for 2017, for example, to 2022, and it has its own chapter in that plan. And it's the first time that the country has ever actually had a competition policy as a explicit part of the reform agenda. Now, I said earlier that that one of the filters it uses, the Competition Commission uses in choosing its cases or activities, the use of or potential impact on consumer welfare. And we argue that the pursuit of consumer welfare standard in this particular case has the effect of enhancing economic growth while achieving a fairer distribution of income. So, and the reason for that is, as I explained earlier, described earlier, what you see in the country and many other countries in developing countries in the region and elsewhere, you see these mutually reinforcing effects of market policy distortions, market power, and rent-seeking activities. And these have perpetuated market inefficiencies, pushing consumer welfare down and the economy below its potential. In other words, inside the possibility frontier that faces the economy. And public choice theory informed us that despite the fact that consumers are numerically large and have much to gain from undoing many of these market distortions, the balance of political power actually works against them. And so the at least vis-a-vis economic elites, so they lose in this battle for political influence over public policies governing markets. So the fact that the competition authority pushes for consumer welfare, we're taking effect serving as a countervailing force to remove these distortions, thereby benefiting consumers. But at the same time, because you are inside the frontier in a highly distorted economy, you're actually moving the economy toward the frontier, and later on, by inducing innovations and other competitive pressure, you get this frontier eventually also shifting upward, and that what could sustain economic growth. So the argument we are making is that despite the fact that we are using consumer welfare standard here, we're actually achieving the greater objective of enhancing overall welfare and overall efficiency in the economy, therefore allowing for a more sustainable growth. Okay, and finally we illustrated this with some examples where we said, remember that I mentioned that we look at consumer welfare, impact of consumer welfare as one of the filters. And obviously food here is one such case where the importance on consumers is large, particularly for the poor. This is the case where the population is ranked from poorest 10% to richest 10%, and those at the bottom are the poorest 10%, and that represents the share of food in the total consumer basket or consumer expenditures. As you can see, for the poorest 30% of the population, 16 to 21% of their income goes to food. And the thing about food in this country is that it's a highly the markets are highly distorted, such that prices are almost 50% higher than what would have been the case if those distortions are removed. And so by removing these distortions, one can expect a much greater impact on welfare of consumers and the lower income groups or low income groups. And so when we do this, when you actually do that, you find that even just removing, reducing the distortions from say 50% to 35%, you actually get substantial reduction or substantial increases in the real income of consumers, particularly the low-income consumers. And if you remove all these distortions, even you get those impacts even more, such that the poorest 10% of the population could experience 12% increase in incomes, real incomes. So by mere correction of price distortions, market distortions, you could, as if you could increase the incomes of the poor by so much. And in this sense, the pursuit of competition policy, particularly advocacy towards removing those distortions, making the markets for food more competitive and efficient, actually works for fairness in the sense that I use in this presentation. I guess these are the takeaway, the last slides. Competition policies and its effectiveness can't be discussed in a vacuum. They must be properly situated in a specific space and time. CP, the competition policy, is part and parcel of the country's economic reform agenda, at least in the case of the Philippines, to achieve inclusive development. And the last bullet there is that says that the pursuit of consumer welfare standard in competition policy enforcement enhances economic growth while achieving a fairer distribution of incomes and opportunities in general. That might not be the case for developed countries, but in developing countries where you see many of those distortions working against the poor, I could bet you get those outcomes. Thank you very much.
Thank you very much for this rich and empirically well-documented presentation. I think it ties in very naturally with the presentation of Professor Baker, who will further discuss the question of inequality, market power, competition enforcement. So I hand over to you.
Thank you. I'm delighted to be here. Thank you to the OECD for inviting me. Is this my, let's see here. Wait a minute, I want to go back to that. There we go. So the last time that I spoke here at the OECD, which was earlier this year, I talked about a number of reasons to think that market power is growing and why the economic evidence should be interpreted as reflecting market power, not just growing scale economies and temporary returns to investments in information technology. Today, I will take it as given that market power and inequality as well are each growing in advanced economies. These trends are most acute in the US, most likely, but they're also apparent elsewhere. And Chairman Balisacan talked about rising inequality in developing Asia just a moments ago. I'm going to talk about the connection between these two trends and about ways that competition policy can help reduce inequality. Now, before I do that, I want to remind you what's wrong with inequality and market power. This slide lists 4 social and economic costs of growing inequality, and again complements what Chairman Balisacan said in his presentation moments ago. First, growing inequality reduces economic growth. Financial hardship and credit market imperfections combine to reduce people's ability to invest in education and training, to change jobs, to learn new skills, or start new businesses. And inequality harms the morale and the work effort of those who are left behind. It also leads to an inefficient provision of public goods that benefit the non-wealthy, like transportation and education, even if they would foster overall economic growth. And second, another cost of growing inequality, it tilts public policy to favor the interests of the wealthy, which potentially creates a vicious public policy cycle that could perpetuate inequality and market power and threaten democracy. Third, inequality undermines the legitimacy of the social order. It lessens the sense that everyone has a fair opportunity and an equal voice. And finally, many people would say inequality is objectionable morally. If I put it in utility terms, a marginal dollar may be more valuable socially if it's given to a struggling family to spend than to a wealthy one. And then towards the bottom, the slide also sketches the costs of growing market power. There are harms in the markets that are affected by the market power. There's a wealth transfer from the from the victims of market power to the firms exercising it. And there are allocative inefficiency losses. There's wasteful rent seeking as firms invest to try and create or obtain or preserve market power. And within the markets that are affected by market power, we see slowed innovation, slowed productivity improvements. Economy-wide, it adds up to a serious problem. Market power slows economic growth and increases inequality. And the main reason that market power increases inequality is that the rents accrue mainly to those who are already much wealthier than most. This slide has some statistics about that for the United States, which I won't go through. But I will point you to research, important research by OECD economists, which I'm citing in the middle, evaluating the contribution of market power to inequality. And they find that market power plausibly accounts for 10 to 25% of the wealth of the richest 10% of the population in OECD countries. Market power also raises the return to capital while lowering an economy's growth rate, which suggests it tends to worsen inequality in Thomas Piketty's framework. Now, nobody should suppose that antitrust enforcement alone can eradicate inequality. For one thing, the antitrust laws do not necessarily reach all exercises of market power. That may be more clear for the United States than for some other jurisdictions because anti-competitive conduct is a predicate for antitrust enforcement in the US. But in all jurisdictions, competition policy may not be able to reach market power that's protected by the government or by intellectual property rights. And at least as importantly, inequality has many causes, which market power is at best one of a number of contributing factors. Antitrust enforcement addresses only the market power channel. And finally, I've been emphasizing a causal link that goes from market power to inequality, but there may also be feedback in the other direction. Firms with market power may be able to use their political power to extend or entrench their economic position, and that possibility increases the importance of deterring the exercise of market power through competition policy, even if antitrust enforcement is just one of many policy responses to inequality. So how should competition agencies that recognize the link between market power and inequality respond to growing inequality? Well, this slide outlines 7 options, which are grouped into 3 broad categories. These are the options that Steve Salop and I talk about in an article that I'll list in my references at the end. Each of them has advantages and disadvantages. So I'm presenting them as options for discussion, not as recommendations. The first category involves strengthening competition overall. Perhaps these are here the advantages no doubt outweigh the disadvantages strongly. Strengthening competition overall promises to reduce inequality indirectly by lessening market power generally. It could be accomplished by giving enforcement agencies greater resources or by reforming the rules. And I have a book that's coming out, and I'll put it in my references, that identifies ways that US rules should be strengthened to address growing market power. The second category, the one in the middle of the slide, points out 2 ways that competition agencies can target inequality in the exercise of enforcement direction, one involving case selection and one involving remedies. So agencies could prioritize cases where enforcement benefits the less advantaged and the middle class. That might include attacking anti-competitive conduct in food manufacturing, retailing, fuel, and healthcare, for example. And Chairman Belisakan's example was rice. It might also suggest targeting the exercise of monopsony power against workers and small businesses. Competition agencies could also design remedies to benefit less advantaged victims. For example, an agency might condition a merger of cable television or broadband providers on the merging firms providing subsidies to low-income buyers. But the remedy, of course, always needs to address the competitive problem first, and it may not be effective when buyers can resell the subsidized products. And the third category, which is what I'll spend more time on, involves recalibrating competition policy goals. I've listed three possibilities. The first, competition law and enforcement could seek to prevent welfare losses to trading partners resulting from lessened rivalry, ignoring the gains and losses to the defendants. So that's a very fancy way of saying several things. Competition policy is concerned with quality and innovation, not just price and output. Welfare losses should be evaluated within an antitrust market using a partial equilibrium framework. Competition policy should focus on preventing anti-competitive conduct that reduces buyer surplus, not aggregate surplus, when sellers exercise market power, and on preventing anti-competitive conduct that reduces seller surplus, not aggregate surplus, when buyers exercise market power. And it also means that competition policy should be concerned with harms to buyers, whether they are intermediate buyers or end consumers, when sellers exercise market power, and with harms to workers and other suppliers when buyers exercise market power. So there's a lot packed into that sub-bullet about the welfare losses to trading partners. And what I described there is more or less what U.S. courts and enforcers do now, except that the enforcement agencies in the U.S. will sometimes decline to challenge mergers that harm competition in one market when the merger greatly benefits competition in another market. But there's an argument in the United States about the welfare standard, which I'll say more about later. But relying on the welfare standard that I describe on the slide does not directly prevent wealth transfers to those at the top of the distribution. But it should work in that direction on average, for the reasons I talked about before, about why market power rents go to the well-off. In some cases, though, this welfare standard could increase inequality. For example, it could prevent price fixing by worker-owned manufacturers of luxury goods, and one might expect that to reduce inequality. The second option in that last category is for competition policy to recognize excessive pricing by dominant firms as an antitrust offense. And some jurisdictions do this now, but U.S. antitrust law has an anti-competitive conduct predicate for enforcement, so it doesn't reach exploitative monopolistic conduct, except possibly under the Federal Trade Commission Act, but that would have to be tested in court. The final option in the last category at the bottom of the slide is to adopt reduction of inequality as an explicit competition policy goal. Now, doing that would have an advantage of directly targeting inequality, but it could also have substantial disadvantages. It may not be practical. Implementing an inequality reduction goal would require a detailed and potentially difficult distributional analysis. And it's especially difficult to determine distributional effects of challenged conduct when the competitive harm involves intermediate goods. It may also be hard to evaluate the wealth distribution of shareholders. For example, when a firm's equity is owned by pension plans that benefit workers. And it probably, pursuing that last goal, probably requires a complex analysis of the incidence of taxes that are paid by corporations and their owners. Another disadvantage of an inequality reduction goal is that it would require explicit trade-offs across groups, which may be difficult, controversial, and divisive. So just to give you a sense, here are some of the hard questions that enforcers and courts would have to answer. Should harms to the poor count more than harms to the middle class? Can the benefits to the wealthy ever outweigh losses to the less wealthy? So would we be comfortable allowing low-income consumers to exercise monopsony power against payday lenders that charge them a very high rate, while not allowing hospitals to exercise monopsony power against nurses? Would we allow automakers to agree jointly to set high prices for luxury models if that same agreement offsets that by lowering prices for entry-level models? Now, the last option on the slide can be understood as an instance of a more general issue that's framed by this forum and this conversation, which is whether competition policy should incorporate social and political goals beyond economic ones. So let me conclude with some comments about that, based in part on the U.S. experience. The recent U.S. debate over antitrust goals may be a response to the two secular trends I've emphasized, growing market power and growing inequality. Before the late 1970s, U.S. courts often referenced other social and political goals along with economic goals, particularly a concern with the threat to democracy and personal freedom from concentrated economic power, and a concern to provide small businesses with a realistic opportunity to compete. Articulation of these goals may have been helpful in ensuring political support for antitrust enforcement. Now, in practice, before the 1970s in the U.S., the social and political goals that I just mentioned were pursued only indirectly. They reinforced the economic justifications for presuming competitive harm from market concentration. But U.S. enforcers never litigated the political power of large firms like Standard Oil. The monopolization cases were concerned only with economic harms. In other words, courts in the U.S. never considered political and social considerations when resolving individual cases under the antitrust rules. When in the era where they talked about those goals, they relied on them only to give additional support for strong rules justified on economic grounds. And that approach was appropriate. Courts and enforcers need to protect the deeply entrenched norm against direct political influence on antitrust enforcement in order to discourage special interest protectionism, partisan misuse of the antitrust laws, and crony capitalism. The current U.S. debate over antitrust goals is sometimes presented as a false choice between the status quo and the adoption of public interest goals. There's some who call themselves neo-Brandeisians who do that by equating the current goal with what Chicago school commentators advocate, and then questioning whether enforcers and courts care about harms to quality and innovation and harms to suppliers and workers. And some conservatives do the same thing, of equating of creating a false choice between the status quo and the adoption of public interest goals when they dismiss efforts to strengthen the antitrust as intended to return to what was 60s era rules in the United States, which chilled efficiencies. And the false choice between the status quo and the adoption of public interest goals omits a better path. In the U.S., antitrust can be strengthened and the error-cost balance can be recalibrated to enhance deterrence by recognizing that U.S. antitrust already aims to do what I previously talked about preventing welfare losses to trading partners that result from lessened rivalry. So I see the goals debate in the United States as a distraction from debating how best to strengthen antitrust rules. On the other hand, and this is my final thought, there are some non-U.S. jurisdictions that have a tradition of looking to public interest goals. And in those jurisdictions, it may be more consistent with the legal and historical norms to incorporate fairness and other social and political goals more extensively than it is in the United States. And I'll list on my last slide one article I happen to know by Harry First and Eleanor Fox that survey the treatment of public interest goals around the world. So what's right for the U.S. may or may not be right for other nations. And I will just conclude there and just point you to a number of references for further reading my forthcoming book, an article with Steve Salop that talks about inequality and antitrust and goes through a lot of what I talked about today, two references from the OECD economists that have done important work connecting inequality and market power, and the article I just mentioned by First and Fox about public interest goals around the world. So thank you.
Thank you very much. And once again, I think the flow of the intervention ties into each other very neatly, because now Fred Jenny is going to address more in detail after we have heard a little bit from the three previous presentations about the foundations of the issue and the debate, the implications for competition authorities.
Well, thank you very much. Thank you very much to the OECD for inviting me in this panel. What I'm going to say, of course, is purely personal thoughts, and I would, equally with Jonathan Baker, would say that those are really options for discussion. I'm going to take a slightly different standpoint from Pinar, because I'm going to start talking about the political economy of competition in Europe and possibly North America, but in that part of the world. I'm going to talk about perceptions more than about reality, and outcomes more than procedures. There's one point, one thing that which is, I mean, if I want to synthesize the difference of approach that we have. At one point, Pinar said that competition law is in the interest of all market participants. I am convinced that in Europe and possibly in other developed countries, this assertion is now challenged by a participant that we are not used to talk about, which is labor. And that this is one of the issues that we're facing when we talk about fairness and competition. So let me, on the broad political perspective, say that it's obvious to everybody that there's a resurgence in populism in the world, and particularly in Europe. And that second, when we talk about populism, what do we talk about? We talk about a view of the world which is based on oppositions, two types of opposition between the people and the elite, with the idea that the elite is corrupt and doesn't represent the desires of the people, and another opposition which is between the inside and the outside. And one crucial element of this is protectionism, which sends us back to international trade. But after all, a lot of the developments that we've seen in competition come from or are consequences of what happened in international trade. And one of the elements of populism is protectionism, including economic protectionism, which highlights the threat to domestic producers from cheap foreign goods, to domestic workers from cheap foreign labor, and to domestic debtors from foreign creditors. And I'm going to say that there's an equivalent for competition, an equivalent threat that competition is disrupting the lives and the status of people. Now, before I do that, I want to tie this to some studies which have been done by the Bruegel Institute on recent rise of populist views, trying to find out what were the determinants at the local level of the increase in the vote for populist. And there are two studies, one of them which concerns the US, which is the vote for Trump, and the other one is the vote for Brexit in the UK. And what is very crucial in those results is that in both cases you find the same result. At the local level, what determined the importance or the appeal of the populist parties is some variation on inequality, whether it's the Gini coefficient in this case, or if I take the case of the Brexit, it is also the Gini coefficient as well as the poverty rate, which are the most significant variable related to the share of the populist vote. So clearly there is a relationship between the rise of inequality, which we have talked about, and a reaction against free markets and competitive markets. Because both of those types of votes led to an attempt to restrict, in fact, the importance of foreign competition and competition in more general terms. So the drivers of economic resentments is the claim that the elite is, by promoting international trade, international competition, domestic competition, is lying and pushing an agenda which works against the people. And that brings us back to the question of what is, among other things, the impact of competition on labor. Now, there's been a lot of thinking in international trade literature where we see a huge rise of protectionism. If you've read the last WTO report, I mean, there are protectionist measures which are adopted by many governments, and this has an actual effect on trade. On why is it that whereas in the 90s and the 80s, I mean, there was this idea that international competition and international trade were good for development and the promotion of welfare, why is it that we have now a problem? And I think that some of the lessons of that debate are useful when we think about competition. David Autor, which I quote here in a series of slides, is the one who was the most, who's been the most eloquent about this. And basically he said, well, you know, what is the model of competition that we have in mind? It's a model of competition where, because of competition, firms try to become more efficient. The firms who cannot become more efficient disappear, and their resources are recycled in other sectors. And there's free entry and circulation in each sector, which means that in the end we have an equilibrium, which is very favorable to consumers because we have the most efficiency, the lowest price, etc. But what's interesting in this model is that it assumes that behind the product market competition, there's a labor market which is undifferentiated, competitive, and very large. Which means that if you lose your job because your firm goes bankrupt because of competition, you're going to find an employment somewhere else. And the impact of, let's say, a bankruptcy of a firm is diluted in the economy, which means that you're going to find another job at the same level of wages. Now, the problem is, particularly with international trade, is that labor markets don't work this way. They are fragmented. People are not mobile. They are therefore geographically fragmented, and also they are fragmented by skills. And the result is that people get trapped. Okay. That's where the assertion that competition law is in the interest of all market participants starts being a little more shaky. Because for those people who are trapped because they are not going to find another job, or because they are not going to be able to move to another place where there would be another job, they don't feel that competition is serving their purpose, and they do feel that competition tends to work well for capital, because capital is very mobile, tends to work well for highly skilled people, because they have the means to easily find jobs, but it certainly doesn't work well for the unskilled people who are caught because of the intensity of competition in situations where they are losing their jobs or losing their means. And those people find that so there are, I mean, I'm skipping those slides, but there are very interesting studies about, for example, when you compare the competition coming from China into the US, the idea is, in principle, from trade theory, that this impact is going to be diffused in the whole economy. It's not going to affect any particular region or any particular people. And you have very good studies by Autor that says that this is absolutely not what happened. What happens is that the effects are very localized and they last forever, or they last for decades, which is forever. Okay, little evidence to suggest that employment gains in non-exposed local industries substantially offset those losses. So there are victims, and the victims are mostly the unskilled labor. Now, why is unskilled labor not mobile? For all kinds of very obvious reasons. One of them is that there's been a change in families, with more members of the family having a job. And if one loses a job, it's not so easy to relocate elsewhere, because what happens to the other members of the family? Okay, so you stay where you are, and you cannot find a job. Or you have small housing, and you are in a depressed area where the last employer closed down. The value of your housing goes to zero. How are you going to get the money to go somewhere else? So it is, there are studies on labor mobility and showing that both in the US and in Europe over the last 30 years, labor mobility has declined significantly, and there's been a negative trend of labor mobility. Now, all this is not too bad if we have ways to redistribute income and make up to the people who are displaced. Now, there are also studies about the effectiveness of the redistribution schemes, or the schemes to try to increase the skills of people so that they will more easily find jobs. I mean, I should have said, which is the fact that one of the aggravating factors is clearly the digital, the development of the digital economy, because that creates a wider gap than used to be between skills. But what we know is that those redistributive mechanisms don't work very well. And we know that in the US. I mean, there are plenty of studies in the US, there are plenty of studies in Europe. Okay. So competition authorities, when they say, well, this is not my problem, it is the problem of whoever is in charge of redistribution, are either naive or misinformed, but I mean, they can't really escape the fact that if competition leads to disruption, and if disruption leads to victims that cannot retool themselves, reallocate themselves in others, those people are going to suffer for a long period of time. So the outcome, it's not so much the process, but the outcome. So this is a study, for example, that on the federal government's program to help workers who lost their job in the U.S., and it concludes that the effect is very bad. I mean, certainly I can speak for France, where adult education to retool people who are unemployed doesn't work very well at all for all kinds of reasons, and I think that this is a common experience. So what do we learn from the trade debate? When there's intense competition with disruptions, capital labor markets do not adjust as economic theory assumes. The losers are the low-skilled wage earners. Capital is definitely on the winning side because it's very mobile, so at least it doesn't suffer. And the highly skilled labor seems to be able to reallocate itself. Now, this creates the idea that maybe competition is unfair to the people who are caught there, and that it is a bit of a ploy, I mean, a bit of a concern in terms of not only increasing inequality, but increasing the unfairness, or the fact that this inequality comes from an unfair reason. Now, this leads, and many authors, both in the legal literature and elsewhere, to a growing, what Michal Gal in this particular case called a growing rejection of competition as part of the socio-economic social contract. The idea that, unlike what we like to say, competition doesn't benefit all market participants, if we include labor in those, and that it has an unequal effect and an unfair effect on some people. Danny Roderick in the US, talking about international trade, recognized that and actually says that in a formula that maybe we could use for competition, that we have mismanaged the process of trade liberalization very badly, because we've made it very unpopular by not looking at this unfairness of the result, or the perceived unfairness of the result. Okay. So Angus Deaton, Nobel Prize in Economics, also addressed this issue and said that fairness is really the problem in those issues. Inequality, we all know, can have dynamic benefits, but when the inequality is something that you cannot get out of, because for all the reasons which I've explained, then there's the idea that it is an inequality which is based on a lack of fairness to people. And he goes even further by saying that there's a second explanation which is sinister, that median income stagnation is the direct result of rising income and wealth at the top, and that links into some of the things that Jonathan Baker was talking about earlier. Okay, so unfairness leads to populism. It's very easy to understand. And I just want to, and I would say that some heads of competition authority are a bit concerned about this, because it's very hard to explain in a pub that everybody benefits from competition, because people don't believe you. Mm-hmm. And the pub test, which I discovered in reading one of Rod Sims, the Australian head of the ACCC, said if you can't explain it in a pub, I mean, there must be something wrong with it. And he goes on by saying, I applaud the economists who wade into the public sphere and will ground their contribution in the facts of everyday life, particularly when that means relaxing the often abstract assumptions of theory, and which is exactly what I talk about. Now, what is fairness? Pinar was very tough on fairness by saying, well, it's a very undefined concept. I completely agree with the fact that there are different dimensions. She talked about procedural fairness, so I'm not going to talk about this. I think that horizontal fairness, as she mentioned, both on the demand side and the supply side, there is a good case for competition for reasons which have been explained. First, the ban on discrimination, for example, or the the fact that we try to eliminate barriers to entry and allow suppliers to enter and therefore to participate. But the real issue, I think, is vertical fairness. So it's vertical fairness can be the relationship between the employed and the firm which employs it, but it can be also between somebody who negotiates a contract and whoever is offering, I don't know, services. Now there, I think that it is very useful to look more closely at the work of Thaler and Kahneman, both Nobel Prizes. So, I mean, some people thought that they were doing serious work. Because, as Pinar suggested, they teach us a lot about fairness judgments. So it's not an objective value, but judgment. And they do find regularities, and they do find, as you said, that people react with respect to a reference transaction, to the outcome of the firm and the transactor, and to what has happened which has made the outcome different from what it was originally. And somewhere this, so I mean, to give an example, but there are many examples that if you have a small shop and you hire someone for $9 an hour, and then the wages in the region go down and you decide to reduce the wage of your employee from $9 to $7, people think that in general that this is unfair. Why? Because there was a reference was $9, and they don't see that it is acceptable to reduce it. But on the other hand, if the employee leaves and a new employee comes in and the new employee is hired at $7, people think this is fair, this is the market price. Okay. So when we use behavioral economics, there are ways to, I think, simplify and get results on what people consider, rightly or wrongly, not discussing this, whether things are fair or unfair. There's a second dimension, which has been mentioned, but not really treated, which is that behavioral economics tells us that fairness matters to people. Well, what does it mean? It means that their objective function, their utility function, includes the utility that they get from the goods and services, but also from the fact that they are in a fair system. Now, we competition authorities, we economists, we say, well, we don't care about this part. We're just going to maximize the utility from the rest. But if there's a trade-off between the two, maybe we're not, in fact, promoting welfare completely. So, I mean, there's a cost of ignoring the issue of fairness. So where does that lead us? Well, that leads us that, A, we are very fragile politically, because we refuse to talk about fairness, I mean, the traditional position, and we say it's not our problem, go back to Pinar, and shouldn't be our problem. But B, that there are some possible solutions that we should maybe think about, and which are along the lines, for some of them at least, that Jonathan Baker mentioned. So I will mention one. First of all, be interested in the competitive mechanism on the labor market. So that would be one. Second, I think that it's incumbent on competition authorities who have advocacy powers and in many countries can choose what they advocate to try to think about advocating for the preconditions that are going to make competition work and be acceptable. And I know that it seems to me that competition authorities have always had a rather narrow view of what their advocacy function should be. I mean, as soon as there is a law that restricts competition in an immediate way on a particular market, they will emit an opinion by saying that this is not a good development and maybe it should be repealed, which is fine. But there could be other types of opinion. For example, it could be that competition authority would militate for everything that would make labor market more flexible by saying, look, if we are going to have competition and for competition to serve the purpose that we need, we don't want to create unemployment. We want to facilitate the reallocation of all factors, including labor, and therefore whatever the government can make in terms of education, in terms of increasing geographic mobility, et cetera, is something which is favorable and which is a useful complement to competition. So I think that in the advocacy field and advocating for more flexible labor market, there is a role for competition authority. The third is exactly what Jonathan Baker mentioned, prioritize anti-competitive cases, which are also patently unfair. And it seems to me that, in fact, competition authorities tend to do that, but they don't. They will pretend that they don't do it, but they do it. And yesterday we had a discussion on excessive pricing, and we were talking about the cases where a pharmaceutical company will increase its price by X 100%. One of the appeals of those cases is that they are patently unfair. And they are patently unfair because what's behind them is a hold-up problem. I started this treatment, and once I've started the treatment, I can't change to an alternative because I assumed that the reference was that there would be a reasonable price that I would have to pay. And all of a sudden, in the middle of the treatment, the price is multiplied by 10 or by 20. Okay, so I'm the victim of a holdup. Okay. Now, we are, as competition authorities, familiar with those because in many countries, there is such a thing, abuse of dependency or abuse of negotiating power. And this is really at the heart of those I mentioned. So I think that maybe it could be useful to have prioritization criteria, which, as Jonathan Baker said, could be designed to facilitate the life of people or consumers who might be particularly hurt, consumers or labor, who could be particularly hurt by competition, in a more straightforward and in a more acceptable official way. A fourth possibility, of course, is to deal with the labor implication of competition decisions. I insist on this because one aspect of the unfairness goes through the labor. I mean, it's not the only channel, it's one of the two channels. So. And the question is, okay, we have a merger, the merger is pro-efficiency, and the competition authority thinks that there's no problem, it's a good merger, so, okay, and 5,000 people are going to be laid off. Okay. Does it matter that in one day, 5,000 people are going to be laid off? Or could it be the role of the competition authority to try to say, look, this is going to create a real problem, a real distrust in market, and also, by the way, is going to create possibly an inefficiency unless you have some plan to try to help this labor find other employment. Now, South Africa has some experience with this. I'm not saying that we should do it. I'm saying that in the possible solutions, that's also a solution. One thing which I do not propose, because I don't think that we're ready for this, because I think that behavioral economics is not sufficiently advanced there, is to introduce fairness as a criteria for looking at competition cases. Because if we know that people have some degree of fairness, we don't know much about the trade-offs that they have, and therefore we would be in a very difficult position to. Now, I just want to finish on the cost of not doing this by referring to the French experience. Okay, so the French experience is like any good competition authority. Fairness is out the scope of, officially at least, out of the scope of the considerations. And the question is whether this is a good position to have. But it's a good position to have if nobody can change the competition law, or nobody can change the decisions of the competition authority. Well, we've had two recent experiences in France from this. There's been a very lively debate about farmers, about the fact that farmers were squeezed by large retail-scale distributors, and that something had to be done because farmers have a lot of difficulty. I mean, they're not very geographically mobile, that's for obvious reasons, and they also have a lot of difficulty being professionally mobile. So what should we do? Okay, so, well, the answer was, well, we're going to impose a constraint on large-scale retailers that they must stop competing on prices on food products, and we're going to make sure that they stop competing by imposing on them a resale price maintenance condition, which says that they cannot resell food at less than 10% more than the price at which they bought it. Okay, and the hope was that this would decrease the tension at the downstream level and therefore decrease the pressure on the farmers. In the debate, publicly, there were people who said, well, this is terrible for consumers. I mean, this is going to reduce consumer welfare. The reaction is it's only fair. I mean, those farmers have a right to earn a living. Okay? Too bad for the consumers. So all of a sudden, you have a big part of the economic activity where a big chunk of the competitive pressures have been taken off by a law. Why? Because there was a perceived unfairness and that competition didn't seem to solve that problem. As a matter of fact, competition seemed to make it worse, and it was unacceptable politically and socially, so the best way is just to limit competition in this area. And then we had an even closer problem. We had a horizontal merger between two firms in the canned food sector, which is more or less a declining market in France. But one of the two firms was bankrupt. I mean, the one which was being acquired, which was the number one in the sector, and was being acquired by number two. And the competition authority said, I'm sorry, but this creates huge concentration in a very narrow market, but so huge market share. This is going to reduce competition. I'm going to block the merger. Now, the consequence of blocking the merger was that the failing firm, I mean the bankrupt firm, which was not recognized as a failing firm by the competition authority, but that's another debate, but the bankrupt firm was going to lay off, I don't know, 1,500 people or something like that. The Minister of Economy intervened immediately, I mean, which he had never done before, by saying this is unacceptable. And therefore, I'm going to overturn the decision because I have the right in special circumstances. And he justified his decision by the fact that those people were going to be laid off in particular regions where the labor market was, where those firms were the only employers, really, and where it was very clear that those people would not be able to find another job elsewhere. So he used the failure of the labor market as the reason for overturning competition. Is this a good outcome? Would the competition authority have made a different decision if it had considered the labor implication of a decision? Possibly. I'm not sure that it's the best, it's optimal to have a minister come in and just overturn the decision of competition authorities from the institutional point of view. So I leave you with those questions. I don't have the answers, but it's quite clear to me that the discourse that says fairness is not our problem is not a winning answer these days in the context, and I completely agree with what Mr. Balisacan said, that there is a regional element to all this, so one has to put things in perspective. If I put this in the perspective of Europe or possibly North America, I think that we have to have a discourse on fairness and try to see what we could do without imperiling our main objective, but we cannot ignore the problem. Thank you.
Many thanks. After this tour de force of these four presentations, I think lots of comments could be made and should be made, so now is the time to move on to the floor, and as I have said previously, there are two interventions that have already been pre-announced, and so I would very much like to give the floor now to Lord Andrew Tyree, the still new chairman of the UK Competition and Markets Authority. I think it's the first OECD Global Forum on competition in which you participate, so a very warm welcome, and please, the floor is yours.
Well, thank you very much for the welcome. As you say, I'm new to the job. Before that, I was 20 years an elected politician, and now I'm a regulator. I've got a lot to make up my mind about. When it comes to fairness, I have made up my mind about a few points, and it's three of those that I want to allude to today. Some of the points have already been made, some in a different way, and some I don't entirely agree with, but I won't pick those out at this stage. The 3 points that I'm going to, in summary, talk about is, first, there's the sense of unfairness and mistrust in markets among ordinary people is now very deep. In fact, it's so serious and persistent that many people are describing this as a crisis of capitalism. And it's even more serious to the extent that populism generates protectionism, as Fred Jenny was only a moment ago suggesting, triggered by the failure of labour markets to adjust, among other things. The second point is that resolving the crisis will require engagement of competition authorities everywhere. We're not the whole solution. We're probably only a small part of it, but if we don't do our bit, we will come to be seen as part of the problem. The third thing I want to address briefly is that if we don't do something about this sense of unfairness, we are in deep trouble. I think our legal frameworks will need to be bolstered. I've been thinking about this for some time already, and I'm not sure what is required to bolster it, but I am clear that some new powers are almost certainly going to be required, and I'll be making recommendations of that type to government. Thinking those issues through, it's very helpful to have the OECD to help bring together experience from other countries. In the rest of what I'm going to say this morning, I'm just going to keep to those 3 points. What exactly have people lost trust in? Why do they consider the outcomes of market competition to be unfair? Why does this matter for competition authorities, and is it any of our business? And if it is, what should be done about it? Competition rules that we operate at the moment are part of a settlement about how we are running the globalized economy. The language of mistrust and unfairness, which we're now hearing loud and clear, is largely a rhetorical shorthand for the collapse of confidence in that settlement. The settlement consisted of an open, rules-based system of international trade and economic cooperation, and a commitment to sound money, which hasn't been mentioned today, and competitive markets. It's a technocratic settlement. Institutionally, it's been held to benefit from the delegation of key elements of economic decision-making, including monetary and competition policy, from ministers to those technocrats, on the grounds that they're better able to take decisions than politicians who may be swayed by what they could gain by varying those decisions at the ballot box, and freeing the decisions from pressures of the electoral cycle. It's largely a post-Cold War settlement, so it's quite recent. It's that settlement that's being challenged, and it's being challenged despite huge economic success that's come with it. Since 1990, just to illustrate this, and we've seen a little bit of the evidence in slides earlier this morning, the proportion of the world living in absolute poverty has fallen from 1 in 3 to 1 in 10. And the global middle class has trebled on World Bank definitions from 1 billion to 3 billion. These are huge transformations. So before we all get too gloomy about the rise of populist nationalism, the flatlining of global trade as a proportion of GDP, the fragility of the Eurozone, I suppose I'll have to mention it, Brexit, it's worth being clear about one fundamental point. We're witnessing what is undoubtedly the most spectacular improvement in the material condition of mankind in recorded history. And that has included many of the poorest, as Mr. Bali Sakan's slide showed earlier. But we need to be equally clear that the discontent we're witnessing, particularly in the more advanced economies, is not merely a public relations problem. It's not that people just don't get it and that they don't know what's good for them. Globalization has brought some very unwelcome side effects, and Fred was alluding to some of those. Perhaps I'll summarize those side effects. The first side effect is that the benefits of integration in some countries has been handed out to a small but highly visible elite. Mr. Baker pointed this out by talking about the distributional impact of globalization in the United States. Secondly, immigration has generated considerable discontent and tension, and that's closely related to the labour market point that Fred Jenny was referring to. And governments have seemed unwilling or unable to respond to it. Thirdly, the pace of change that's come with globalization has left many with a sense of insecurity about their own and their families' jobs and livelihoods. That insecurity will be aggravated by artificial intelligence, which will both eliminate and create millions of jobs at great pace. All of what I'm describing, except perhaps AI, was going on before the financial crisis, before 2008, and it's important to bring that home, that point home. But millions of people in that crisis drew a clear set of conclusions. It focused people's minds. Perhaps I'll summarize that as well. A first conclusion was that large financial companies were there to rip them off. Mr. Leitenberger referred to the rip-off culture in his remarks. The second was that they, the public, were going to have to foot the bill for the mistakes of these financiers. And a third was that nobody was going to be held accountable for any of this. In fact, the bankers appeared to walk away with a good deal of money from the crisis. So the institutional fabric of our societies in and beyond the OECD was already being challenged before 2008, but it's received a second very powerful challenge as a result of the consequence of the financial crisis, reinforcing the first. Since the crash, many people have started losing faith in the established institutions of their country. What's more, those people are much better equipped than they used to be to make themselves heard. Nearly 90% of people have internet access. Many are using social media to express their discontent. Nearly half of young people in the OECD have tertiary education. Deference is in decline. Actually, I think all those developments are forces for good, but nobody should be complacent about the consequences, and I saw that firsthand as an elected politician. So the second major question I was trying to address at the start, or said I would address, was how much of all this is really the business of competition authorities? Well, part of the settlement I've described was the orthodoxy that economic growth and productivity were best supported by market competition. So it should come as no surprise that there is now rising public and political scepticism about the orthodoxy. For many people, we, that's us here, the experts, the regulators, are simply no longer protecting them. For those same people, business, and particularly big business, is just a rip-off. 3/5 of people in the UK, and I'm citing evidence mainly from the UK today, I hope people will allow me that, 3/5 of people in the UK do not trust business. Nearly half of those people think that business does not operate honestly and that it takes advantage of the average worker. Anti-capitalism is not a fringe movement. The discontent is now deeply entrenched across a wide political and social spectrum. And again, the problem is not merely one of perception, it's real, whether it's catastrophic mishandling of personal data by the likes of Equifax and Facebook, opaque and excessive charges for essential banking services, price gouging by big pharmaceutical firms, price discrimination against the vulnerable, for energy, insurance, and other essential services. All of this adds to a growing sense that consumers are poorly served and left behind, and that they're being poorly served and left behind by exactly those people they thought were charged with sorting it out. That's us. Many argue there's a lot of rent-seeking going on. Mr. Baker alluded to rent-seeking. In the UK, profit margins have risen from 1.2 in 1980 to 1.7 today, even as the share of investment in GDP has fallen. That's quite high. Very high profits look to the ordinary consumer like, again, exploitative practice. There are claims that this increase in profit margins has been caused by an increase in concentration, and there's a good deal of academic literature about how concerned we should be about this. But it's certainly true that concentration shot up in the financial sector after the financial crisis. According to the best polling evidence, financial services account for over half of all consumer detriment in the UK. And so the relationship between the concentration number and the detriment the evidence of detriment is worth bearing in mind. What's more, looking at it on a global perspective, the market valuations of some of the tech giants implies that they will become still more dominant in the future, and that therefore they are expected to find new opportunities for rent seeking. For while the growth of the digital economy has dramatically improved consumer welfare and empowered small firms to obtain access to vastly larger markets, it has also thrown up new opportunities to exploit monopoly power. I think one generic argument, we just need to pause to address one generic argument against action. Everything I've said so far implies we must do something. I haven't said what we should do, and I'm not sure what we should do. But let's just pause to make the case against any substantive action. Some argue it's none of our business. Some argue that unfairness in any case as a concept is so vague that it should be set aside by competition authorities. In enacting on it, we would end up exceeding our remit. Before I wrote down these remarks, this point was made to me quite a bit. Some go further. They argue that in taking unfairness into account, we will undermine the credibility of the job that we can do and that we should do. Our role as unelected technocrats, so the argument goes, extends to securing economic efficiency by preserving and promoting the competitive process. No more. Anything beyond those bounds, including the protection of the vulnerable from the depredations of the modern economy, should be a matter for politicians. I think that might have seemed a strong argument in the years of the Great Moderation, but I think it's anachronistic now. Competition policy and economic regulation more generally may not be a panacea to all forms of economic injustice, but we cannot and should not do nothing. Either we need to ask for powers and duties to address some of the unfairness, or at least we must have the courage to tell politicians, and noisily if necessary, that it's their responsibility and say so publicly. Unless we get those tools and use them, or at least, as I say, have the confidence to speak up, we will inflame the crisis of legitimacy. We may damage not just the process of competition regulation, but the wider settlement to which I alluded a moment ago. Why do I say that? Well, we don't need to look into the crystal ball. We can read the book. Look what happened to the financial regulators after 2008. Several of them, including in the UK, were abolished altogether and replaced. In other countries too, there was radical regulatory reform in response to the financial crisis. If we as regulators can't be part of the solution, I think we'll come to be seen as part of the problem, and that will put at risk the foundation of an independent regulatory regime that I think we all strongly support. So to sum up the case for action, there's a growing gap between what politicians and the public expect of regulatory authorities, including competition authorities, and what the public are actually getting. As a result, we're at risk of allowing our moral authority to dwindle, and we could be putting at risk what could be described as the social license to operate handed out to us by politicians. We would be putting at risk altogether, in a way, the settlement that I described at the start. So I want to end, if I'm given the time, with just addressing in a few remarks what I think should be done. I am at early stages of thinking that through, and I think we're all working on this, and you can get the sense from the panel that we're all working on this. But I'll add just three thoughts. First of all, and Fred alluded to this by suggesting that regulators say they don't do this, but they do. I think that was his remark. We can use the tools we have got already to do quite a bit. Secondly, we can set out what new duties and powers we might need. Thirdly, we can be much more deeply engaged in public discourse about the problem than we are now and its solutions. Perhaps I'll describe that as public advocacy. Just on the existing tools, putting concerns about fairness and trust closer to the centre of our agendas, that's what the CMA has been trying to do right now. In recent months, we've acted to improve standards in the care home sector. We're undertaking a study into the funerals market, and we've been acting to clamp down on secondary ticketing rip-offs, recently winning an important case. But the truth is, in practice, we often get thwarted, even when the detriment is blatant. The central problem for the CMA is that despite great theoretical powers and responsibilities, we appear unable to act with the speed and flexibility increasingly demanded by my former colleagues, the politicians, with whom I still keep in close touch. The more I think about it, the more I'm coming around to the idea that responding to public and political dissatisfaction will require quite a fundamental rethink about our duties, our powers, and our approach. Hence my second point, we need to be prepared to reconsider the framework as a whole. That was the word framework, was the word used by Mr. Leitenberger earlier. Our duties may need to be redefined. We may need better to put the consumer's interests first, demonstrably first, rather than orientating ourselves first and foremost as a body concerned with competition. Competition for the benefit of consumers. That change in the law may be declaratory if we were to secure it. It may have more profound effects on the way law is interpreted. These are questions that I'm thinking about right now. I'm also considering whether we should try and take specific account of vulnerable consumers in our duties and powers who are at greatest risk of suffering detriment. After all, it's principally their reasonable complaints that politicians are picking up and throwing back at us. I'm not yet sure that we should tread this path, and it throws up a number of very difficult questions, some of which have been referred to today. I'll just, in single sentences, ask a few of them. Is it ever legitimate for unelected technocrats to exercise discretion over matters of distributional fairness? Where does the regulator's duty to vulnerable consumers end and the government's begin? How would we manage a conflict between the interests of vulnerable consumers specifically and consumers more generally? How should we handle a trade-off that might result between overall economic welfare and fairness? Pinar referred to that point, I think, in her presentation. I haven't made up my mind about what to recommend to the government on those issues, but I am thinking about them. In principle, we might seem to be in a good place to handle this in the UK with the markets regime. This is certainly a step forward on what many countries might argue they've got in order to deal with these problems. I won't linger on it now, except to say that when one looks carefully at the rules and tries to use them, one finds quite often one is hemmed in by procedural restrictions. And it could well turn out that that very framework needs more robust tools if businesses are going to have a stronger incentive to comply earlier with recommendations. At the core of a markets regime, in my view, has to be an approach which gets the earliest possible settlement rather than playing out the process right through in the courts. I saw that very vividly when looking at financial detriment, financial market detriment. My final thought on what we need to start thinking about doing was what I described as public advocacy. If we're going to act on all this, we've got to take the decision ourselves either to demand those powers or to explain to government what they themselves now need to do. That's not an easy job for a technocratic regulator to undertake. In the UK, again, we are helped because our statutory duties and the strategic steer we get from government already demands that kind of advisory steer now. We need, and I think we should, try to help government think through much of this. They too are faced with the same set of challenges. But we also need to be aware this may involve speaking out against the tendency of all governments to protect vested interests or to buy votes with popular but ultimately misguided intervention. Again, I'm at early stages of thinking that through. So to summarise, and simplifying a lot, I want to leave you with just three thoughts. Addressing fairness and trust is our business. We may need new tools if we're going to make a difference. And thirdly, we need to engage much more with our governments and our wider publics to explain why. The reason was given by Mr. Leitenberger right at the start. The framework and the settlement is probably right. But if we don't get on with this work, we will find ourselves being forced to reform it in ways that damage it rather than make it more robust.
Thank you very much. I would now ask TUAC to come in with their intervention. And given that very clearly the richness of the theme, the width and breadth of the issues raised is also posing a challenge to our timing, I would like to say two things. I think I have the permission to slightly go beyond midday, 12 o'clock, in the conduct of this forum, so that we can still have contributions from the floor beyond the pre-announced contributions. I would invite those wishing to intervene already to raise their nameplate during the intervention of TUAC, because that will allow me then to see who still wants to come in and to try to conduct the final part of our conversation this morning with the best possible intelligence. Now, TUAC, you have the floor.
Thank you very much, Mr. Chair, and good morning, everyone. My name is Séverine Picard, and I will speak today on behalf of the Trade Union Advisory Committee to the OECD, that is the TUAC. Mr. Chair, you started the session by saying you were hoping for a lively and controversial debate, at which point I thought it's a wonderful idea to give the floor to the trade unions, because this is what we usually do, be controversial and lively. However, I must say I am a little bit surprised and delighted to hear the presentation that I heard this morning, and you will see that a lot of what I have to say are in the continuity of some of what you've heard. Now, how can competition contribute to fairer society? Well, to us, the trade union movement, there is no neutral approach possible. Competition does need to take responsibility in the fight against inequality, and you do that already. I mean, a fair treatment of consumers, we've heard it, is seen as a goal for competition. Market power becomes dysfunctional when there is no incentive for quality and innovative products at a fair price. But what I want to say today is that more is needed. More is needed than the usual competition discourse. And I want to use a single but very concrete example, and that is the case of online platform. So I want to talk about market concentration in the sector of online platforms. Now, online platform is a very sexy topic. Everybody talks about it, including in this house. Yesterday I was at a meeting where somebody said online platform is a new bling bling. So it is. But just to be clear about what I'm talking about, there is a definition that has been used by the OECD. An online platform is a digital service which facilitates the interaction between several and independent users, producers and users. Now, the dominant position of online platform has already alerted a number of you, or must have alerted a number of you, especially with regard to the data capture of such companies. What would happen if these platforms were to adapt and to target their selling techniques according to the huge collection of personal data that they have? And in fact, they already do. We are aware of techniques such as price algorithm, where platforms are able to adapt and adjust their prices and selling techniques according to each of our personal behaviors on the internet. But I also hear the argument that considering the huge level of innovation required in the tech sector, considerable investment must be made into research and development. And what I hear is that in order to do so, a solid financial position is required for digital companies and online platforms as well. I also hear that dominant position is not prohibited per se in competition law. It is the abusive use of dominant position that is prohibited. So what I want to make, and I'm going to make the point very briefly, Mr. Chair, is I want to make a case for breaking up the dominant position of online platform in the name of fairness and in the name of equity. You have all heard of monopsony. A monopsony is a situation where there is a single or dominant buyer on the market. And it is particularly problematic when it comes to labor market monopsony, because such monopolies lead to lower wages and more precarious working conditions. A few examples. Mechanical Turk, M-Turk. It's an online platform for microtasks where workers compete to offer DIY jobs. Now, according to a study of this year, should the platform pay a 10% lower wage, the platform would only lose around 1% of the workers willing to perform the task. So there is a very high degree of market power here, which is linked to significant wage losses. Another example, Amazon, one of the most well-known platforms. Workers in US and UK Amazons are subject to terrible working conditions, poor health and safety, and very aggressive anti-trade union tactics. Now, Jeff Bezos has announced an increase of wages in the US recently. In parallel, benefits have been suppressed in the UK, and there is no indication of fair wages in the rest of the world. Other platforms, Deliveroo, Uber, they all rely very heavily on self-employment business models, whereby the workers are self-employed and they are paid less than if they were actual employees. They nonetheless remain under the full control of the platform, and there is also a problem of contribution to public finances. Now, I've heard this morning some concerns that competition authorities do not wish to be overburdened by unrelated notions, but these are not unrelated notions. These unfair terms and conditions I've just described can easily be translated into competition terminology. Unfair terms and conditions. I refer here to, for instance, algorithm marking workers for bad behaviors. Price fixing, the price in this case being the wage. The wage are being fixed. There are also contractual arrangements preventing workers from working for different platforms. Mr. Jenny referred to this as the no poaching clauses. And linked to the price fixing problem is the refusal to deal. The platforms do not recognize collective bargaining, and there is a very aggressive anti-union tactics. Limiting production. It is now demonstrated that Amazon, the business model of Amazon, has led to a considerable number of job losses in the US. So all this to say that there is a clear need, in our view, to integrate the employment aspect into the competition policy. Now, I've heard in the past very often that the saving made by the buyer, in the case of a monopsony, will be passed on to the consumer. But in the case of a labor market monopsony, the consumer is the worker. So when you have a market concentration which leads to poor working conditions, the worker suffers a double penalty. As a worker, its working conditions are worsened. But as a consumer, its purchasing power is shrinking. And what we see is that the drop of wages that we're seeing everywhere in the world, the drop in wages has a deep effect on inequality. And this effect is not addressed by a hypothetical drop in prices. We are losing the battle against market concentration. So integrating employment into competition is actually going to help you to address the anti-competitive effects of market power. To regain ground, competition does need to build bridges with other parts of policy making. And I'm just going to conclude here with 5 recommendations for further work. Number 1, the first challenge for competition authority will be to develop a well-functioning methodology to include employment in order to assess the existence of a dominant position. The ability of online platforms to impose lower wages and poor working conditions without losing their workforce is a strong indicator of market concentration, problematic market concentration. Recommendation number 2. We do need to develop policies to strengthen labor law and collective bargaining. Collective bargaining allows workers to address the asymmetries by raising collective voice to set acceptable standards. Recommendation number 3, and this has been mentioned this morning as well, the potential impact of mergers and acquisitions on employment does need to be assessed. In particular, careful consideration should be given to labor market monopolies before approval is granted. Number 4, look at good corporate governance. This is something that you do not do, you're not used to do, I believe. However, in other parts of this House, it is also well recognized that digital companies and online platforms in particular are developing techniques to shield their own corporate governance from the scrutiny of investors and the public in general. So there is a bridge here to be built between the good corporate elements and policies designed to increase transparency and accountabilities of those companies should be a part of an effort to bring the spotlight on unfair business practices. And fifth and final point, coherence with other policies such as trade and tax is particularly important. On trade in particular, domestic policies that aim at facilitating the entry of smaller competitors on the market should not be treated as a form of protectionism. Quite the contrary, they are here to contribute to healthy competition market. And you have a role to play to develop or to help this discourse. And there is also an issue with regard to the taxation of large digital companies. And I can tell you that should you start some work on the volume and handling of data by online platforms, you would attract the attention of the tax expert. We are currently discussing if and how intangible assets should be discussed. Thank you very much. Should be taxed, sorry.
Many thanks. We have a very limited time now available for further interaction. With the help of the Secretariat, I have identified 3 requests for the floor from Ireland, from CATS, from Consumer International, and the 4th is now coming from South Africa. So I would take these 4 interventions with the request to all participants to be brief, because I would like to give one final sentence to each of the participants here on the podium before concluding this session. So Ireland, please.
Thank you, Chairman. Isolde Goggin, Chairperson of the Competition and Consumer Protection Commission in Ireland. Thank you for a most interesting discussion. I won't go into it all, but I just wanted to share with the forum some of the experiences of the Irish Competition and Consumer Protection Commission in dealing with issues of atypical employment or vulnerable employees in Ireland. Going back to 2004, the then Competition Authority had issued a decision finding that groups of specific categories of self-employed individuals, that's voiceover actors, session musicians and freelance journalists, were undertakings and as such were not subject to the protections of trade union law. They didn't have collective bargaining rights. This was obviously opposed by the unions concerned, and legislation was proposed at various stages to effectively exempt these categories. That was again opposed by the authority, not so much because these were particularly significant markets, but because of the sort of slippery slope argument whereby other self-employed professionals who provide services to the state and where the state actually spends a lot of money, so doctors in general practice, lawyers and so on, whether they could then collectively organise and act effectively, threaten to withdraw their services or go on strike the state. So in 2017 then legislation was passed providing an exemption from competition law from the Section 4 of our Act, which is Article 101, for those particular categories of employees, and providing the possibility for others to apply to the Minister for similar treatment. There were certain protections in there, so it would only apply to a sort of a smaller markets, and it wouldn't apply where a significant cost would be created to the state by these collective bargaining rights. And, you know, and I think that's a kind of reflection of the point that others were making, where competition law, we treat people as consumers, but people are also employees, they're also citizens, there are other aspects. I won't go into all that, but I just wanted to say, I suppose, what we see as the pros and cons of having specific exemptions or separate legislation to deal with these kind of things, rather than expecting competition authorities to factor them into their decision-making under the current legal framework. So the pros, I think, are that it provides clarity. You're not expecting competition agencies to factor in a whole load of areas which are not necessarily within their expertise into their judgments. The cons, I think, would be the slippery slope argument. At what point does this start to impinge on the expenditure of the state? At what point does it start to actually create costs for consumers? There's also, within that category of atypical employees, false self-employed and so on, there's a degree of inequality in there as well, because the ones who get the exemption are the ones who are unionised. And there are many other categories, I think, particularly in the sort of delivery, the gig economy, particularly delivery issues, where those people are not unionised. So again, perhaps there's a division of rights and equity there. Thank you, Chairman.
Thank you. Katz, please.
Thank you very much. Uday Mehta from Katz International. I have a very specific question for any of the speakers who would like to take it up. So there's been a rich discussion on fairness. So my question is, fairness for whom? Is it for the relatively well-off consumers based in developed countries? Or are we talking about fairness for the poor cotton farmers based in Zambia, for example? So I think if fairness is the goal, then we should also speak about who are the beneficiaries of such fairness. Thank you very much.
Consumer International. Sorry, you need to use the microphone.
Oh, sorry. Fairness is embedded deeply in consumer protection regimes. So things like the unfair terms in consumer contracts in the EU and fairness provisions in other countries such as Australia really illustrate this. The practice in consumer protection has been to develop notions of fairness often in specific sectors as aims for the industry, so we see it in the finance sector. So although fairness might be woolly and ill-defined at the moment, the experience from the consumer policy sector or consumer policy enforcement shows that it can be a useful conversation to have. And in that case, and perhaps where it crosses over here, it could focus on corporate culture and looking to enforce gaps or failures such as excessive pricing or data harvesting or privacy invasions. I think what's really important for us to bear in mind is that the language of regulation is as important as the fact of that regulation. And when we think about some of the points that's been raised here in relation to the idea of the pub test, that Frederick was talking about, consumers in the political community will recognise discussions of fairness, and so that taking it on board in this community could really help the legitimacy and the understanding, and therefore the ongoing potential to act that this community has.
Many thanks. South Africa.
Thank you, Chair. I think the problem has been well exposed. And as typical, I think, of a competition discussion, we know about the problem and the laws talk about it, whether it is unfair pricing, excessive pricing, price discrimination. All these, I think, are founded in the notion of fairness. The problem is what we do about it. What are the tools within the competition space to address this? And I just want to mention two things. The one, I think that we really have to think about out of the box about this balance between efficiency and inclusivity. Because when it comes to small business, I have come to accept that maybe you will have some inefficiencies in certain markets, but where you have a large SMME sector, often informal, it seems to me that if you have to integrate it to the formal economy, you have to promulgate rules to help the SMME sector. And by the way, this is the sector that everybody accepts employs more people. This is the sector that everybody accepts that it has to drive innovation for the future. I think competition rules need to help it a little bit. I think the problem of labor also has been discussed. I think when it comes to issues of measures, again, I think there can be more direct tools used by competition authorities to mitigate the impact of large measures on vulnerable employees who not only sometimes lose jobs, but sometimes lose their bargaining position because the market power acquired by large firms simply enable them to bargain better terms with employees. Thank you, Chair.
Many thanks. To conclude, as I said, one sentence per participant in the panel. We'll take the same order as the initial presentations. Professor Ackman.
Thank you. Thank you. It might be a very long sentence, but I'll do my best. So much has been said and so many important issues have been raised. I think if I were to say just one thing, after hearing all of this, it would probably be to say that if fairness is to become a part of the assessment, I think this has to be done on a principled basis, on the basis of a framework that has been established by Parliament or by authority policy ex ante, so before the event rather than after the event. And I don't think, listening to everything we have heard today, I don't think we have that framework or probably anything close to that principled ex ante framework yet in terms of how to incorporate fairness. And until that point, competition authorities would serve societies best if they continue doing what they're most apt at doing, which is to serve the interests of consumers by tackling anti-competitive practices in the usual way. Thank you.
Many thanks. Mr. Barizakan.
Thank you. I maintain that making, in the context of developing countries where job creation is obviously far more important from the viewpoint of welfare than protecting jobs, because in less developed countries, nobody can afford not to have jobs. But the question is whether the job is of high quality enough that could improve well-being. And so to the extent that competition policies open up opportunities by making markets work so that labor can move to where they can secure higher returns to their labor, that's what makes a fairer society, Mr. Chair.
Professor Becker.
Thank you. My takeaway from this discussion is that in the current political environment, competition authorities are facing increasing pressure to address concerns about distribution when attacking market power. And agencies can successfully respond with stronger enforcement and prioritizing the cases to investigate and perhaps remedies to account for distribution, and reasonably describe doing that as addressing fairness without altering their focus on the traditional competition goals. But I want to emphasize one caution. In addressing fairness this way, it's not necessary and it's not advisable to bring in politics when determining whether competition has been harmed, because that's a recipe for bad outcomes in the long run that undermine competition under the guise of protecting it.
Thank you. Fred?
I just wanted to maybe, as a follow-up to what South Africa said, emphasize the fact that this issue of fairness and competition is also quite relevant in developing countries, particularly when it comes to the part of the population which is in the informal sector, not by choice, but by inability to enter into the formal economy, lack of property rights, etc., etc. The discussion we're going to have this afternoon on gender equality speaks quite a bit to this, because in certain part of the world, it's mostly the women who are in the informal sector because they do not have the opportunity of being, and they are treated in a sense by the system unfairly. So I think that the over and beyond the specific situation of Europe, I think that the discussion we had on how we try to think about fairness without compromising or goals of promoting efficiency can be applied in many different environments. That's what I want to say.
Many thanks. We have spent over 2.5 hours in an extraordinarily rich discussion, and yet we are far from exhausting the subject matter. I have taken myself several pages of notes and questions, and of course the temptation is enormously now to add to all of this with a few thoughts of my own. I will refrain from this, not to build a dominant position of the European Commission here, because this afternoon Commissioner Vestager, I think, will deliver what I could not conclude better. Maybe just one final thought that I would like to leave you with, and that is that fairness has indeed a procedural dimension, a due process dimension, and therefore a timeliness dimension. In the long run, we are all dead. And maybe also part of the reflection on fairness is, before we even move to new frameworks, to new tests, that we look at whether we are bringing in a timely manner all the cases that we bring now, whether we subject them to judicial scrutiny at this point in time, rather than building scruple, over scruple, over scruple. Accuracy is fundamental, but justice delayed is justice denied, as the saying goes. With this, I would like to thank the participants in the panel. I would like to thank the Secretariat for having hosted this fantastic discussion, and I would hand over to Lynn and to Fred for the further announcements on the conference. Thank you very much.
Thank you. So I have 2 orders of business for you. One is we're going to do our group photograph. The more efficiently that you move to the stairs and the more efficiently you have your photograph, the faster you'll find yourself in front of the buffet lunch. So I would encourage you please to move quickly over to the stairs so then you can have your lunch. The second thing is there's some of our colleagues, some of the countries, we have a side meeting for you, those countries of North Africa and the Gulf region. Please signal yourselves to the Secretariat after the photograph, and we can escort you over to room E. Thank you. Fred, do you have anything to say?